Good morning. I take appearances for them to please the court, Mr. Bashir and Mr. Waikwa, for the first petitioner. I and Mr. Awele, who is present, and for the second petitioner. And we also hold for the third petitioner. I know she will be joining us later. Ms. Leah Ezekiel is present holding brief for Ogola for the third respondent. Third interested party, I beg your pardon. And Ms. Mutemi is here holding, appearing for the fourth interested party and holding brief for Ms. Mutemi for the fifth interested party. Ms. Mutemi for the fifth interested party. Or Ms. Mutemi is actually present for this. She is the one holding brief for Ms. Munga for the fourth interested party. I beg your pardon for that. And Ms. Joroge, together with our senior, Ms. Soweto, for the sixth interested party. That ends the appearances for the petitioner side, and over to my learned friend, Mr. Regero.
Good morning, you have a very high speed. I'll slow down a lot. So for the first respondent, Ms. Dong is holding brief for Mr. Peter and Mr. Ogoso. I appear with Mr. Tuwo for the second and third respondents. Mr. Nyamodi and Ms. Dong for the fourth and seventh respondents. Dr. Nyamodi for the fifth respondent. Mrs. Adera holding brief for Mr. Mwendwa for the sixth respondent. And Mr. Ochieng is here for the first interested party. I'm told Mr. Tuo is holding brief for Mr. Macharia, who appears for the eighth and ninth interested parties.
My lords, as Mr. Regero sits, I want to go on record that Mr. Victor Kamau and Ms. Pigui have come for the third position. For the third petition, please.
Maybe I'm not sure how to respond to this.
Don't do it next time.
So we are proceeding with the cross-examination of the expert witness. Dr. Bononga is in court and take the witness stand. Now, Mr. Bashir, yesterday you indicated you just need 30 more minutes.
That's my plan.
You would be happy if you can take less than 30 minutes.
I think the morning will enable us to think. There is one or two possible issues.
Yes.
Number one, our clients are extremely grateful for yesterday's ruling and for the accommodation that was extended to them by the court. And they asked me to confirm that they will do everything to ensure that they are available those 2 days. 2nd and 3rd of October for the 2 PSs and Royford Murray, we should have returned from China. For the PS interior, Dr. Kibuchi, everything being equal, the plan is that he testifies on the 2nd. We intend to call him on the 2nd because in the evening he has to travel out of the country on official business. So as your plan, our diaries, the expectation is if we could possibly finish with our 2 witnesses today, Brian Mwenga and Mr. Muchemi, paving the way then for the 2nd when we can call Dr. Kibicho. Hopefully he can finish on that day. He travels and then we can continue with PS Ochieng and Mr. Murray. And if for any reason, say we are not able to finish with our 2 witnesses today, Mr. Mwenga and Mr. Muchemi, who knows, we could possibly seek to indulgence so that maybe we even extend to tomorrow. We have tomorrow's date will get a petition about 63. And it is deemed useful that if we don't finish this, that we take, even if it's a little time tomorrow to finish, then we will put that to the court at an appropriate time. The second issue has to do with the recorded proceedings. We look at appreciation that the court has made efforts and the proceedings that have been recorded. So presumably at some point, these can be available to us so that we can use them in terms of preparing submissions and so on in a timely manner.
Okay.
Thank you.
Yes,
Allow me to indicate that tomorrow would not be convenient to our staff.
Now, we actually intend to finish with the witnesses today, even if it means sitting a bit late. So, but I would urge the participants as to put that in and they come is the director to the court. As for the recorded proceedings, we'll make arrangements. I was informed that what you may need to provide us with are flash disks so that we can be put on the flash disks.
We'll do that.
Okay, so for Mwenga, you reminded you are still under oath. If you are comfortable sitting, you can sit down. Mr. Bashir, you are ready.
Thank you, Madam. Good morning, Mr. Wood.
Good morning.
So we'll proceed from where we left off yesterday. And you remember we were talking about trust in the identity service provider, specifically as you outlined in paragraph 16 of your affidavit. And I have begun to talk about the petitioner, the first petition. You remember? Mr. Mwenga, you enrolled for a Huduma number using your national ID.
Yes, sir.
And So Mwanga, you did this because you knew you needed to access certain government, essential government services in the future. As a law-abiding Kenyan.
Yes.
So Mwanga, you're aware that it is the respondent's position that without this ID card, you would not have been able to enroll for the Budiman program.
I'm actually not aware.
Yeah. You, reference is made to paragraph 9 of Kimoto's affidavit.
Who's that?
Mr. Kimoto.
Kimoto.
Yes, where he references the documents you need to enroll for NIIMs.
What is the 7?
Yes, Nadia. So you don't know whether without the document you are enrolled.
I'm not certain about that.
You know that?
Yeah.
You have read the documents of the past petition with regard to issues of discrimination. This is response to that. And you were present yesterday when they were testifying about the challenges they face in acquisition of identity documents. And it is the position of the respondents that you cannot enroll without this vital document. This logically means that they will not be able to get to do the movement. Right?
If it's according to them.
Yes.
If the system is described accordingly.
Yeah. So you agree that just like a law-abiding Kenyan, you went to enroll yourself for a human, but some Kenyans would not be able to enroll themselves, and they would not enjoy the same benefits that you did. Do you think that would be unfair?
If the system works as you described, that would be unfair.
It would be unfair. Thank you, Mr. Mwanga. Yesterday, Mr. Mwanga, we talked about the fact that you've done and you've been a beneficiary of several contracts with the government, correct? Including the one which, with the library, which is not yet renewed, right? And the one for the library is under the Ministry of ICT, correct?
No.
The library falls under which ministry? In these contracts that you involved in, Mr. Mwanga, did they include conducting a cost benefit analysis?
In this particular one,
All of the contracts that you did, some did, some didn't.
yeah, some did.
So you're familiar with the cost benefit analysis?
Yes.
In your affidavit, you state that, and I'm paraphrasing here, that cost benefit analysis means weigh the benefits on one hand and the costs on the other hand, in order to render the decision, right?
Yes.
In order to weigh these costs and benefits to someone, we agree that, or in order to do it rigorously, we agree that using numbers will help in this process, right?
Yes.
You agree, Mr. Mwanga, that you've not abused any evidence of these numbers showing the benefits and the costs of the NIIMs project, right? You have not adduced any evidence in your affidavit or otherwise, you, Mr. Mwanga, showing the numbers, comparing the benefits or the costs of the NIIMs project. Have you or you have?
Benefits can be financial. Benefits can be social.
I'm asking you about numbers. You have not adduced evidence in numbers form of costs and benefits. Have you? You haven't. You do agree that the NIIMs project is a big government project, right?
Yes.
You agree with me broadly that this project is being financed by the Kenyan taxpayer, right?
I'm not aware about the finance.
Okay. You do agree that the Kenyan taxpayer is a significant stakeholder in this process, don't you? And you do agree that the Kenyan taxpayer should be aware of the costs and benefits of such a project, right?
I would say yes.
You say, yeah. So you do agree that the Kenyan taxpayer should be involved, at least with the numbers of the costs and benefits of a project like this. Thank you. And you've not submitted that in credit. Mr. Mwanga, you talked about in your document, which is you've attached to your affidavit, in the architecture of the government enterprise document. This would be my lady. Is that's off page number 4, correct? Which page is that? Yeah. Yes. Page 4, the handwritten annexures. I mean, BG02. If you reference some of the principles, you outlined principles in there, correct? Of how presumably these are the kind of principles that we consider in the project that we described.
As my recommendation.
As this would recommend.
Yes.
You talk about principle number 4, maybe that would be page number 12, and listen. Next page number 12. This policy was outlined.
So when we talk about information being a national asset, right? And you state this is an asset that is needed by citizens and leveraged across the government to improve performance, right? And importantly, someone that you state, a well-informed citizenry is necessary to our democracy, right? Yes. A well-informed citizenry is necessary to our democracy. Yesterday we talked about the NIIMs system, and to make it accurate or deterministic, you need more and more data points, right?
That is one way of solving that problem.
We did discuss that yesterday, right?
As one way of solving the problem.
Now, would you agree that a system that seeks more and more data, for example, a system that has a lot of data about you, someone is that the should clarify to you as a citizen something about how it's designed, architecture. And do you think this would be useful to enhance trust? Correct?
Not necessarily.
So you see,
I would say it depends on the context.
I'll give you the question again. A system that has, and we just talked about principle number 4. It said, I go to you again, someone said, and well-informed citizenry is necessary to our democracy, right? And access to information would improve government performance, right?
Yes.
So my question is, having the citizens understand, and I include you in that, right? Having the citizens understand, and the more the citizens understand about this system and architecture, it will improve performance.
It's context. I'm discussing about data.
Okay.
So there's different items.
Your answer was not.
If I may explain.
I will ask. I'm trying to understand. So you said no or yes, or it depends. It depends. I'll come back to that. I'll come back to your principle. Okay. To your best knowledge, and as a government expert, have you tendered any evidence about the design, architecture of it? No. And we discussed yesterday that the NIIMs system is deterministic and accurate, the more data points it has, right?
Yes.
So the more information it has, the more accurate it will be. And yesterday, Mr. Mwenga, we talked about DNA as being one of the data points that is available for use, correct? There you go, that.
Yes, identification.
Identification, correct. Now, I put it to you, Mr. Mwenga, that it is very worrying, and it should be very worrying to you also, that the design, the architecture of this system has not been tendered into evidence. Yet, the system requires more and more data, including, and not exclusively, being correct?
Well, I'm not sure whether the system is collecting DNA.
No, I'm saying to make the system more accurate. You said it in Aadhaar, it needs
This is a hypothetical.
what we talk about in Aadhaar is hypothetical.
Well, based on what the system is collecting right now, and
Okay, the system is collecting a lot of personal information, correct?
but as I stated, the system is also using
It's
a
the
different
system.
method to be deterministic. So we're speaking about a hypothetical. So if we use
Okay,
my
let's-
advice as to how the system is being made deterministic, then DNA does not appear anywhere. In the
DNA
explanation I gave you yesterday.
DNA does not appear anywhere in making a system. You said DNA is even probabilistic as well, right? You said all forms of data collection are probabilistic, right?
Not necessarily.
Is there any single type of data that is deterministic?
Yes, indeed, like a unique identifier is deterministic.
And a unique identifier is a number.
Could be a number, yes.
Thank you for that. A number which, if you don't enroll in the system, you don't get, correct?
Logically, yes.
A number which people who don't have, IDs, passports, birth certificate, because of contextual timing, they will not be able to get, correct?
I just said I didn't quite know whether the system required all those. I would assume they are failover.
Thank you very much, Mr. Moon. That's all.
Mr. Wayne?
Good morning, Mr. Wayne.
Good morning.
So I have a few questions for you. And I'd like us to concentrate more on your understanding of what data protection is and privacy of personal data collected. With this. Now, yesterday you gave a very extensive overview of your professional and academic qualifications. I'd like us to just very briefly touch on that. I'd like to understand, Mr. Mwenda, in all your academic competence, have you at any point interacted with the subject of data protection and privacy and personal information?
Well, data protection in general, yes, as a topic under security.
Okay. In your actual professional practice,
Yes.
you have.
Yes, I have.
In relation to anything you have done and which you have listed in your CV at your level? Anything you can point out?
Not necessarily on my CV, but just
What is the nature of that interaction? Explain what exactly that interaction or
making sure that the data of the client was actually secure in storage and in, also in interaction. That the data of the client I was dealing with was secure in storage and in interaction and so on. So we're looking at there's something called secure software layers, SSL. So for instance, when you're doing financial transactions, you ordinarily have to encrypt a lot of that data, making sure that it's actually protected. And then also in terms of backups and encrypting those backups. Yes, so in practice.
So basically you understand the general theory for why it is important to protect customers. At least from a general understanding of this.
Yes.
Now, you have set out in your CV various consultancies that you have undertaken on behalf of the organization. In particular, I'm referring to page 27 of the affidavit. All through to page 28 of the page 27 and 28, in particular page 28 of the affidavit. Is there anything there that you have done that was specifically in relation to data protection and privacy?
This is on the page
28. Of all the assignments you've undertaken on behalf of all those public institutions there, is there anything there that had data protection and privacy as a component?
Page
in your work?
Page 28 has some initiatives. Page 28 has some initiatives and some volunteer work.
Please just point out there. I'm talking about specifically data protection and privacy.
Yeah, I would go to page 25.
25. Yes.
And I would probably bring attention to the enterprise architecture for the Ministry of Health.
What about that consultancy with respect to data protection and privacy?
There was actually a very big discussion around the privacy of medical records. Do you want me to continue?
Yes.
Well, the interesting thing about privacy is, at least in the discussion that we had with the doctors, is that you indeed need to give the doctor some data so that he treats you. And in as much as you give the doctor that data still remains, it's still yours. Yes, you're actually the owner of that data, and you then give access of that data to whoever you wish for purposes of obtaining service.
Okay. So basically, it would be fair for me to conclude that it was the conclusion of that discussion that data protection and privacy is the component of an affidavit filed on behalf of the state respondent in this case.
Yes, sir.
This is the affidavit of 14th of May, 2019. You have read and understood this document.
Yes, ma'am.
Now, by Mr. Brown, he's out. Correct. You have sown this affidavit in response to the petition's findings.
Yes.
Part of paragraph 6 of your affidavit. You say that you were sought out to provide explanations of the various technical issues arising from the petition's findings. Okay.
Yes.
Presumably, therefore, you have read and understood the petition.
Yes.
Would you kindly just summarize what your understanding of the petition is?
Well, I mean, it's indeed summarized within the affidavits,
Yes.
and my particular input is.
No, let me help you. Let me help you start. You understand why the petitioner what concerns the problem.
Yes, of the issues that was set in front of me to address, I do understand that.
I want you to just give me a general of what those issues.
Yeah, there were quite a number about actually in relation, most of them in relation to the accuracy of the system or the possible accuracy of the system. There were issues about centralization and security, about open source, closed systems, about basically on the number of things that I've actually tried to respond to in terms of advice that I gave.
Let's get into tight. Yes, we have to listen to the affidavit, the principal affidavit of Mr. George Egoro. You have it. My ladies and gentlemen, I'm referring to the petition itself, the second petitioner's petition. The first page is the reality. And the other page is the fact of the affidavit.
This is petition about
Yeah. Yes. Yes, sorry. 15. I'm sorry. 18. Okay, 35. Mr. George Egoro. Tyrants. Well, all of them are tyrants. But they are not their ancestors. It's a fight. Would you kindly just read out that paragraph 15, paragraph B, Roman 1. That's the inference.
In principle, the petitioner is not opposed to the proposal that citizens be assigned unique national identification numbers. However, unless the concerns regarding the security and integrity of the system, as highlighted herein, are addressed, a unique identification number as a central access platform will exacerbate the risk of compromise of the system and by extension the privacy and security of the people.
Does that in your view fairly summarize what this petition is about? I earlier asked you whether you understood this petition and asked you to try and summarize it. We struggle with it, but now I will show you is that a fair summary of what this petition is about. The concerns. I'm not saying you agree with them. I'm just asking you whether you understand that as a fair summary of what this petition is about.
Broadly, I'd say it.
Do you think those are legitimate concerns?
Indeed.
Why?
Simply, also simply because data can be misused.
And when you say data, you mean data that may be personal. Yes. Now, you have in paragraph 6 of your clarity deed, the entire testimony before this court revolves around a system of needs. Now, can you just very briefly tell us what needs is and how it works?
I cannot confidently give you an answer to that question. Why? Because my involvement in the NIIMs project can be thought of like at really the initial stages, because that's the result of some of the work that I did. And beyond that, I just give advice, and the client is the one who then decides on the design and implementation based on advice that is given.
Okay. So you do understand that in certain parts of your application, which now you have given opinion based on your perception of what the community is, right? So using the same analogy, you just briefly tell us what in your view means this.
I would say, first and foremost, it's an integrated identity system. So it's we don't call it a composite of IDs that were initially there, and basically a collection of identification data that had already been collected by government people.
This is the first part of the second. What does it say?
That specifically Kenya's civil registration data is partial and disjointed. The data is collected without any unified standard, with each collecting institution setting its own standard, leaving a challenge of reusability and verification across all other institutions. Well, this necessitated the setting up of a single identifier standard and a verification exercise by going back to source and hence the data collection.
So what you have just informed the court, you agree with this are correct. NIIMs is not the integration of the system. It's the fresh collection from your own system.
Not necessarily.
As to what names state, we say names is an information system that sits and we put together. And I ask you to read paragraph 10 and you have just confirmed that because of the weaknesses of the existing registration systems, that necessitated, those weaknesses necessitated the setting up of a single identifier standard and a verification exercise by going back to source and hence the data protection. So do you agree that names is basically collecting fresh data? No. No. Right? So what do you mean exactly by that?
If you proceed further in my affidavit and look at UN's definition of
Let's
registry.
we come to that actually.
Yeah.
I am very keen on understanding what you meant by particularly the setting up of a single identifier standard and a verification exercise by going back to source. What do you mean by going back to source?
Going back to source simply means, in this particular respect, going back to your decentralized version of the registry, which is IDs that are held by individuals. Yeah, I had already, yes.
So in your opinion then, there is no fresh data possible.
Not really. I think they're collecting data that, well, they're collecting the decentralized register that is already there amongst the people, which is the ID that you hold.
So they're collecting information that is already contained in some sort of report. That's in manual form.
Yes.
At paragraph 11, you say that identity in relation to access and security like the people modification, something you know, something you have, something you have. Please read paragraph 12.
That any or all of the say to three authentication methods may be incorporated in identity systems, whilst it has become common practice to combine the same modes, which is generally agreed that a most robust factor of authentication and identification is based on something you are, and that is binary.
We have an existing database of registered identity.
I think we have many.
We have many.
Yes.
What is the nature of this technology?
There's fingerprint, there's face. I mean, when I go to get a certificate of good conduct, I give my fingerprints. When I enter the country, I give my fingerprints. They take a photo. They take a photo of my face as well at the airport. My ID has my fingerprints and my photos as well.
Yes. It's time to the petition and the one. This is one of the second petition. Can you please read to the court what that amendment defines biometric as?
So biometric means unique identifiers or attributes including fingerprints, hand geometry, yellow geometry, retina and iris buttons, voice waves, and we also see when fake acid. Yeah.
So out of that list, leaving out fingerprints, do you know of any existing precedents for any of the other biometrics you have out? No. All right. So basically, we were trying to understand what we do. Would you agree that if this additional biometric information is obtained, then this system has to connect? Right? It is provided for you. If you just to connect, this system has to connect. If you just to be stored something, you can use this system.
If it's not there, then it has to be collected.
And it will be collected and therefore processed for specific
use.
And in order to be processed, it would have to be stored somewhere. Would you agree that that then forms the entire framework of what this system of actual processing and storage? And in fact, when it comes to using retrieval, you agree that that then summarizes what it means?
I would say yes.
Now, is it your evidence in this case that means, as you understand it, right, is properly conceptualized in the existing law to perform the functions for which it has been created? The reason why you ask is your evidence in this case, based on your theory, that means as conceptualized in our law is appropriate or sufficient to perform the objectives for which we
I could take it, yes, but the truth about it is I'm not a lawyer. I don't quite know the legal framework around these. But if you do have any technical questions about
yeah, that was actually the next question. You don't understand
the legal framework,
but you understand that there exists a law that what this means.
I would believe so. I would believe so.
Now coming to the technical aspect of it, is it your evidence that the architecture of means as described sufficiently addresses
Based on advice that I've given, I think if that advice was taken, I would be confident as to whether the client has implemented it is something the client needs to answer.
that advice? Yeah. Now, under the auspices of high-tech innovation network, we have in fact provided official advice to the government pertaining to the Government Enterprise Act. And this question I took which we have today, paragraph 5. We have provided official advice to the government of Kenya on Government Enterprise Act. Correct?
Yes.
And this report is contained at pages 24, 29 of your affidavit. That's the report. Is not that from page 4 to page 22 of your affidavit.
Yes.
So, would it be a fair conclusion to make if I say that your advice on government enterprise architecture was basically for the creation of best practices and standards for various ICT solutions for government? I could put it differently. What was the government enterprise architecture? report.
Yeah, so the goal of the enterprise architecture is to basically assist the government in it's a management tool, particularly of technology.
Yeah.
And it ideally helps the organization or the institution in question to chart its path towards digital transformation by managing 3 different layers and domains, which are its business processes and the rationalization of its business processes, the data domain, and then the applications domain and the infrastructure domain.
Correct. So basically, you have sort of proposed certain standards and practices that every ICT solution, inter alia, one of them, ICT solution, should comply in order to be efficient.
I would say yes. I mean, not necessarily that I prescribed standards. I actually gave you patients.
Yeah. But what you believe are best practices.
Yes.
And just for clarification, I noticed that the report that you have attached there is marked as a draft. Let's look at the 8. Yes. The watermark there is marked as a draft.
Yes.
Can you confirm that this report was in fact handed to the government or to anything?
I would say yes.
All right. So let's go on with your report. The architecture that you proposed recommends that all the technical ICT services for the execution of government business processes are defined through legislation, policy, and strategy. Right? That's the age of that report.
Yes, that's the environment.
Why is it necessary to define these solutions through legislation? Why is it important? Why do you feel it important?
Simply because the systems are going to exist, going to be domiciled within a given place. So I keep coming back and saying in the design of IT systems, context will actually define what is designed. And one amongst the context is definitely the law of the land.
The law of the land. Yeah. Would you agree that for certainty, it's important to define all these processes in the law to align them with the existing law?
I would think so.
Right? Same reason for aligning them with policy.
I believe so.
There's a strategy this guy now the execution. Yes. I'd like us to just before we go through your recommendations, you supplied to court a bundle of documents, and my ladies I'm referring to the bundle of documents filed on behalf of the respondent was filed yesterday. It's a standard document. You have provided there, among others, the regulation, the EU General Data Protection Regulation. You have referred to this regulation variously today.
Yes, sir.
And you have referred to this regulation basically as stating what you deem to be best standards, practices, legislation. So you understand exactly what it is.
In large part, I would say yes.
So I want us to go through some of the recommendations that you've made to the government. And in doing so, yesterday, while being cross-examined, you confirmed that out of this report, you recommended the creation of a new national
Identity.
identity. And it is, of course, on that basis that you advise responsibility with respect of the.
Yes.
You agree that the recommendations that you have made in this report would apply to NIIMs just as they would to any other ICT system of the government.
Yes, yeah, I guess. In context, yes.
I'd like us to go through some of these recommendations you have made. This time to page 12. Page 12 of your affidavit. At page 12 of your affidavit, you just flip back to page 11. It starts from principle 1 on architecture principles.
Yes.
So page 12 is a continuation of those principles, and specifically with respect to principle number 3, you recommend there that for the security, privacy, and protecting information, that security, privacy, and protecting information are core. Right?
Yes.
So it is a recommendation that systems must be secure. Correct?
In this particular case, the government has to secure it.
It has to. It's a recommendation that it has to. It has no option. Right? Now, turn then very quickly to page 19. Page 19 of your affidavit. Again, now this time under security, security architecture principles. Again, you emphasize that security controls should be compliant with predefined security policies. Right? Yes. At the same page 19, principle number 2 of security architecture principles. Principle number 2, you recommend that levels of security of information systems should be relative to the risk and harm that would result from the loss, misuse, disclosure, or modification of information. Correct?
Yes.
The sum total of all these three recommendations is that any system for the collection of data for government use must be secure. Yes, must be secure. And the definitions of security and levels of security must be predefined by security policies. Predefined.
Yes.
Correct? By what security policies? Why do we recommend it? Why should they be secure and why should they be predefined in security policy?
I would say that it's really a question of access to data and who has a right to have access to that data and for what reason. Yes.
So basically, it all boils down to protection of privacy.
Well, protection of data in general, if protection of that data protects privacy, I would say yes. But if that data is needed for purposes of, for instance, giving you service, like the example I gave you of the doctor, then I think that's now where you have to be. You have to ask yourself questions as to why who is accessing it and for what purpose.
Right. But
So if it's government service,
yeah,
that requires to identify you for purposes of giving you that service, I think that's very reasonable.
but either way, all this should be very fine in some ways or some legislation.
Yeah, my recommendation is that
It should be fine. Have you seen, in fact, I showed you the nature of data points of information that you want to collect and the relevant laws that establish the biometric of data. So that, yes. Do you agree that this information is sensitive personal information?
photo of your face.
You agree that some of it is
Yes, some of it.
some. That in order to ensure that the data control of the person who administers the data is actually adhering to those standards in terms of having the appropriate levels of security for the various data points that have in place. We would agree that it is important to know what steps they have taken to provide those levels of security. It will be important for purposes of holding them to account to understand what those levels of security could be.
In general, I would also agree in terms of cybersecurity in general. Disclosure of your security architectures and disclosure of basically how your entire design is.
No, that's what
is as well is actually putting the system at risk.
Yes, I understand. What I'm asking you is whether it is important to set out with some reasonable degree of certainty what the standards, what the levels, what standards, the levels of security that you are employing for a given system are, in order for third parties to hold it to account in the event that it turns out later that in fact you do not employ the appropriate standard for the relevant information that you hold.
Okay. Your implementation plans can be kept secure, and in that way can actually make your system more secure.
You say, and you agree with me at principle one, that security controls should be compliant with redefine security policy. It asks you why the importance of this policy is redefined. Yes. Why do we recommend? This is the law. Why do we recommend that they should be redefined?
So that the data is not misused
That's it.
or access someone who doesn't need to access that data.
So it's about accountability.
Yes, I mean an element of it.
Given that you understand what the petitions concern is, you think that if you redefine the security policy, if the security policy of NIIMs, the architecture of NIIMs, are redefined, those policies would perhaps assuage the concern of the community. So say the system may not change them. Do you think redefining those policies would assuage the concerns later can be?
Well, I'd say that's a fairly good question. The way I'll probably approach it is that this data has already been given to government. Concerns about its security were not brought up before, simply because there was probably some confidence about how that data was to be stored. And the government is currently probably showing an intention to improve, I would say.
But what this is due with the conclusion of concerns on the system is whenever brought up.
Well, I would open up
That one. So you would agree with John that such a policy, someone which concerns any defined policy, protocol, legislation, regulation that tries to set up the security protocol or standard of business. You know, necessarily going to be active, protocol and all this. Just the standard.
I would assume there are
No, how to see it.
no.
Now, at paragraph 40 of the affidavit, the still on security. You say that even if one was able to gain an authorized access to the state national master population register, means that is impacted, and then mask the personal information affected, they still need be covered in significant commercial value. Do you mean to say that the only risk that happens to the loss of personal information would be the risk of it being commercially exploited? Another way, you understand any other risks that will attach to the unauthorized access.
Well, this is the yes, there is.
Do you understand the extensive capabilities of being You understand this petition, you read this petition, responded to it.
Also,
You have a chance to read Mr. Davis Malonga's affidavit. So you understand the capabilities. And you understand DNA is on the
as usual.
Now, do you understand also that because of the sensitivity of personal information, as you said earlier, depending on what information is collected, a certain level of security is collected. Depending on the nature. You are attached to your documents in support of your affidavit, the European Union General Data Protection. You can please turn to paragraph 38. Paragraph 38. What does that regulation recommend with respect to children's data?
The position of data protection.
No, 38 to children from paragraph. Validity is involved and the paragraph. These are the recitals. The paragraph 38, recital the key. Let's do the first sentence.
Children merit specific protection with regard to their personal data, as they may be less aware of the risks, consequences, and safeguards concerned, and their rights in relation to the processing of personal data.
Thank you. Paragraph 51.
Personal data, which are by their nature particularly sensitive in relation to foundational rights and freedoms, merit specific protection as the context of their processing could create significant risks in the fundamental rights and freedoms.
Go on.
Those personal data should include personal data revealing racial or ethnic origin, whereby the use of the term racial origin in this regulation does not imply an acceptance by the union of theories which attempt to determine the existence of separate human races.
Great. This is a document that you have supplied to this court as setting forth somewhat best practices. If you agree with me then that whatever you have read out resonates perfectly with your recommendation to the government as regards levels of security to be attached to data, depending on what they contain. Page 19 of your affidavit, principle number 2, security architecture principle. You agree that that is in fact the rationale for your recommendation under practice.
I'd say yes.
Yes.
It's an instrument.
You understand what in data protection lingo is referred to as privacy by default and privacy by design.
Well, I couldn't follow.
It is referred to as Article 24 regulation. This time we will Article 24. Yes. Article 24. I'd like you to go to Article 24, sub-Article 2. Can you please read that dramatically?
Were proportionate in relation to processing activities. The measures referred to in paragraph 1 shall include the implementation of appropriate data protection policies by the controller.
Right? We're talking about the obligations of the data processor and controller. And by controller, you agree that in the context of means verifies the administrator of the, yeah. So Article 25, data protection by design and by the default. Just please quickly read Article 1. Article 1.
Taking into account the state of the art, the cost of implementation, the nature, scope, context, and purposes of processing, as well as the risks of varied likelihood and severity for rights and freedoms of natural persons posed by the processor. The controller shall, both at the time of the determination of the means of processing and at the time of processing itself, implement appropriate technical and organizational measures such as pseudo-minimization, which are designed to implement data protection principles such as data minimization in an effective manner to integrate the necessary safeguards process in order to meet the requirements of the regulation.
I think our best practice standard recommended in your own evidence. What? If you agree with that recommendation again, it's perfectly in sync with your recommendation in principle number 2, page 19 of the Now, let us now come to this. If you kindly tell us whether you know of the security measures that the Ministry of the Government has put in place to ensure the personal data provided under the NIIMs is secure and cannot be used for unauthorized purposes or for purposes for which it is protected or any other purpose.
I cannot answer the question. So I give advice to the client. It's the client's it's actually the client's decision.
Yes.
As to whether to take the advice or not, or based on their or operating environment and the understanding of all the other.
But then the affidavits, this comes from paragraph C. Because of paragraph C. In relation to NIIMs specifically, the states as opposed to the personal information including special images and images is kept as encrypted. Right? Is it your testimony? Yeah. That means that's what is encrypted.
I would assume that's common practice.
That's common practice. It is that. Now, do you also agree that encryption is not necessarily uniform, that there are standards?
I would say yes, there are different types of encryption.
And you also agree that of course, the different types of encryption mean different levels of security.
That's all.
And you are aware of the current encryption standards. Are you familiar with the term advanced encryption standards?
Based on encryption, I would, at this stage, I would actually refer to encryption based on the size of the keys. So we're looking at 32-bit keys or 64-bit keys. Yeah.
That's exactly what I was telling you. No, the current recommend encryption. Now that you know the kind of information you know is collected and the sensitivity of the sensitive, you know the existing encryption standards in the industry for this kind of information. What would you recommend?
I would. Well, that's also a question of context.
Let's just try. The government is collecting DNA and all manner of data points. Yes, which we are doing first.
Yes.
What would you recommend as a different standard this time?
If you're looking in terms of context and you're trying to recommend a system, in this particular case, you would ask yourself, because the higher the encryption and the higher the encryption keys you actually put in place, the more it will cost you in terms of infrastructure, it might affect system performance. So all those actually, the correct answer is not a blanket answer. You actually have to ask yourself, how quickly do I need to, because you can over-secure a system, and as you're over-securing the system, you actually affect its performance, in which case it doesn't make sense to actually have the system.
So for purposes of the information being collected, in your view, do you think that it is sensitive enough to ignore cost implications in the procurement of appropriate activities?
Could you repeat the question?
In your view, do you believe that the kind of information the government is sensitive enough, right, to ignore the cost implication of, say, the most expensive and the best expensive?
I would say no. That's a question that actually depends on the objectives. Basically, the fitness.
Before we become the objective, I'm now on just the data. We agree this data.
But we can't look at the data in isolation.
We are now, let us, you understand that I stand here on behalf of the petition.
Yes.
Their only concern is the data that moves from them to another. Let us just go to David, Mr. Mona. And principle number 3, page 14. Yes, page 14. So we have to do it. In fact, let's start at page 13. You recommend, Mr. Mona, right?
Yeah.
That data should be accessible from Wi-Fi. Principle number 2. Yes.
Yeah.
Principle number 3, page 14. Page 14. Yes, we are David. We recommend that data should be shareable and that data should be centrally controlled and managed at the appropriate organizational level. Yes. And therefore, you understand that once my personal information leaves me, there is no way of telling what to happen. It is beyond my control.
Well, it's an assurance that you need to be given that you.
Before you get the assurance, whether the assurance is there or not, once my data leaves me, violation is digital.
Yeah, it's
especially in the context of the understanding of how technology works. Once it leaves, it's beyond the control. Yeah. And so, taking that into account, typically, by their very nature, the cost implications of the best encryption standard out there should not matter. Or they outweigh the cost. The sensitivity of this data far outweighs the cost implication of providing the best encryption standard available out there.
I mean, based on what I've said, you can actually infer that. So you have to make a decision.
Yeah. Let me use what is it? You would agree with me that it would be in the best interest of the world that a reasonable encryption standard for this kind of thing. Yes. Yes. Now, having said that for this kind of data encryption, you know the encryption standard we all deploy this data collecting and that's a dispute. You don't know. At the beginning of the recommendation, we recommended that ICT government is supposed to align with legislation. In fact, in one of your principles number 1 of the 19, you say that this policies should be verified. Yes, you believe that if in this case the government was predefined the encryption standards for this kind of information is correct, perhaps that would have been some. I would say at principle number 17, page 17 of your academic principle number 2. You have recommended that collected data should be confidential. Correct? Yes. And that privacy cannot be guaranteed by technical science. Okay. That's principle number 2.
Open standards.
Oh, confidentiality. Yes.
Yeah, I mean, in general, when you're looking at security, you're probably looking at, you're actually much better off looking at security from a 360 perspective, not just in terms of technical implementation.
Exactly. And these technical standards, would you know ordinarily industry best practice and standards, how they are to be known or to be set out in what form?
Could you repeat that question?
You say that privacy cannot be guaranteed by technical standards. I presume again, go back to the guideline. This standard ordinarily or these technical standards are you agree first of all that personal data should be confidential. Correct? And of course, that will require certain standards to ensure that data is confidential. Yes. Yes. And these standards you have recommended. Yes. Now, are you aware of any regulation that sets out this standard in respect of confidentiality of information contained in it?
I would believe that the government does have policies as to how it deals with data that's
Are you aware of it?
in its possession.
Are you have any actually in
I might be wrong, I'm not a lawyer, but I've heard about secrecy acts. I know about confidential, top secret. I mean, that's just probably general practice amongst those governments.
and you understand that something is secret, something is protected under the State Information Secrets Act. It is protected in the interests of who? The government or the owner of the
Now that's a legal.
right? Now, if the Official Secrets Act provides that, the law itself, the text provides that you shall not disclose certain things. In your opinion, does that prevent, especially in your IT one, does that prevent any person from doing so, from committing a crime?
Well, if the law states it, the law has to be followed.
Yeah, but usually. I mean, we have the law. Let me give you another example. The law prohibits. Have you ever had a case where someone was married? Yeah. But the law exists. Yeah, using the same example. If the law prohibits the disclosure of personal data, that then third parties from accessing any disclosure data.
And actually, in terms of
For an
how
authorized person.
for an authorized person.
Yes, even whoever. Even within the government itself, just cheeky characters from accessing the data and using it. Does that necessarily prevent that kind of risk?
But the fact that there's a law
Yes.
doesn't necessarily stop crime.
Yes. But you agree.
I agree with you. Yeah.
So you, and in fact, you agree that that is why you recommend that in addition to the law, certain technical standards have to be in place to mitigate the possibility of such.
They will assess the law.
And you, of course, you can say much aware of an actual conduct of this. Paragraph principle number 3, page 17. Yes. You have recommended that systems be open based on open standards. Yes. To promote choice of the and avoid the law. Okay. Why do you recommend it?
This is driven by general principle, which is good practice of technology neutrality.
Technology neutrality, what does that mean?
Yes, that simply means that ideally what you would want to do as good practice is you wouldn't want to lock yourself with one if you're using a standard that is fairly available and well known and implemented by a lot of technologies, then you stand a better chance to get a gain on systems, get a good price, get maybe even teams that have used, you could say, that technology more often.
And therefore competitive. The best out there. I mean, that's the reason why.
But yeah, on a certain class of systems.
Now, in very simple and plain language, what you have basically said that is that this recommendation is important for purposes of, among others, transparency, and accountability. So, I mean, if you have,
if I get on, if I use open standards, you know, like for instance, open standards in this particular case, if you're doing, let's say, data transfer between systems, some of the standards you have for instance, for API, APIs, application programming interfaces, you have standards called REST, which means these are machines that, or these are servers that are on the internet. If you actually use a REST standard, it is much easier for your system to communicate with systems through the internet. That doesn't mean that your entire system has to be open.
yeah, I'm not talking about the software. I'm actually like, we are talking about the vendor, and you have said the objective of this is to achieve the travels, and all the travels.
Yeah.
And the benefits of this is to ensure that you get the best systems that would be available for the radio.
Yes. So if you actually read this, it's if you read the entire document in totality, one of the things that it really tries to achieve is interoperability within government.
Yeah.
So you're looking at a typical problem that I alluded to, that there was probably a registry that was using its own standard to collect maybe IDs for birth certificates. And then you have another system that uses different standards to kind of do that as well.
Yes.
So the government, which should ideally probably have been operating as a unit on one issue, has, as you could say, disparate and disjointed data on, let's say, your identity. So it becomes very difficult to give assurance as to whether one system is better than the other. So that's one aspect. But typically what you're looking at is, for instance, in situations in the area of enterprise architecture, there is one, I could say, a fairly interesting realm called orchestration and composition, if I can just, and we have a very good, yes, we have a very good example in Intergrated, where in Intergrated, if you're coming into the country, you probably have to interact with various number of government organizations and institutions. You probably need to deal with KEBS. If you have medicines, you might need to deal with the Poisons and Pharmacies Board. You might need to deal with income tax care rate. You might need to deal with, so that there are quite a number of government organizations that come together to give a service to one individual. So interoperability within government is an advantage to its efficiency.
And you agree that it also advances the idea of checks, across government ministries.
So this is in terms of operation. Yes, and yeah, if you're thinking about it in terms of has this person actually got a certificate for the medicines is bringing in, then yes.
And you know that checks, what comes checks, and all these balances are functions of transparency and accountability. I mean, the only reason why people want certain people to check whether they are actually forming the qualifications that are in the hospital is to ensure transparency and accountability. Do you agree that the Ministry of Interior is accountable to?
I would assume as part of the Kenya government.
You understand the place of transparency, accountability, and there is ability of the sensitivity in our Kenyan legal framework.
I wouldn't necessarily place that as well.
We agree with that. Finally, on the principles, principle number 2, we recommend you recommend what you call security measurement for government entities. And you recommend that this be done by audits to ensure that risk is maintained at acceptable levels. Right? Acceptable to who you consider the say audit of government systems. Or rather the standards that are being employed for auditing government system should be accepted. The data controller or the owner of the data.
Sorry, just repeat that question.
To whom do you believe the standards for measuring and audit of ICT, the security of ICT should be accepted?
I think
It should be to whom? The government, the controller, or the owner of the data? Or to whom?
I think to both all the stakeholders involved.
Exactly. Now, are you aware of the measures or standards that have been put in place to audit the new system for compliance with whatever standard they have set up?
No.
Would you, because you're not aware, of course, that means that there's some level of faith. And you have agreed that these standards should be acceptable to both the government and the owner of it. Would you agree that you should assume and these standards are at least set out in some easily accessible the standards, just the standards.
Standards.
Including
Well, refers to the fact that you can trace. So we're looking at probably logs, which is I think it's a typical implementation of any system. You should be able to track the activities of people inside the system. So the recommendation here is, especially with respect to security, it is fairly important for you to, if at all there has been a breach, figure out where the breach started. Very first question inside the security is which was the point of entry.
let us take the analogy of financial fraud. Run this. And you're aware that it was starting section. And you are that these standards are publicly known.
Okay.
Right? So that whoever is going to rely on the purchase can actually confirm that the statements have been audited in accordance with certain known standards, and therefore place some trust. Okay? Perhaps at paragraph 16 of your affidavit, you fortify that view, paragraph 16. And then you make a case for why systems should be trusted, and how they should be trusted. And you say law and policy is one of the ways of gaining people's trust in the system. Would you agree that if the government, first of all, are you aware of any publicly available information on the audit standards for
I would know, but I would assume the government has
But you're not aware
audit
of
standards for its system.
standards? Where we have the standards available for them?
Not that I know.
But you recommend it. Of course. You recommend it. Principle,
Yeah.
you recommend it.
Yeah.
No.
I don't.
And you would agree that if this information was public and out there, a lot of the standards would be there.
That
With
is,
respect now to this particular issue of the
I agree. In the context of security, I would say no, because again, if you actually lay out your entire security group, that is not necessarily good for security. In fact, I would term that with a little bit practice. Particularly
which
if
standards out there
for a system that you want to be secure.
Yes.
So if we say that I really want this thing to be secure, so I'm actually going to publish all the security implementations or standards that are used, that would actually be a little bit irresponsible in my case.
I'm saying that if we create standards against which a system such as NIIMs should at all times be measured, that would somehow affect or compromise the spirit of that system. Without disclosing the details of
Well, if you're not disclosing details, then I guess it can be acceptable. When you just say that I've encrypted it.
Okay. No, but remember, the direct encryption, and you say that even in the case of encryption, it will be how you yourself
Different levels.
there's different levels. And therefore, depending on the nature of the collected, it will be important to know what encryption standards can be put in place for that kind of, or what encryption standards would be expected for that kind of.
And I say that level of encryption is a balance on a number of other factors, including performance.
Yes, but also include the nature.
And the nature of information.
Paragraph 17 of the affidavit. This is not talk about the population system, and this is not what I am. Paragraph 17 of the affidavit. So when you have set out what you view the factors and the content and form of population first.
Among them.
At paragraph 15 of the affidavit, you have made the bold statement that in fact, government has the unfettered discretion to determine the form and content for population. Would it be accurate to me to assume that that population register can only be the data collection kits used to input data?
So I don't.
How would complement the information? Just
Yeah, it can be collected electronically, physically.
you can. And it is only the information that is collected, only the information that is collected, that would ordinarily find it here.
Well, the requisite information that
That is collected. Right.
well,
Where is the information from the patient? If you don't get it.
it can be collected from other registries and entities.
Like the resources without obviously.
Yes,
So
using
in other words, what I'm saying is that at some point, that information has to come from someone.
yes.
In the case of names, it will be, I think it's only that I refer you to the amendments. Please turn to page 64 of the second petition. Paragraph P, 9, section 9, uppercase A, sub paragraph 2E of the amendment. What does that provision provide?
To prescribe in consultation with the various issuing authorities a format of identification documents to capture the various forms of information contained in the identification document. Paragraph D, for purposes of issuance of a single document.
So you agree that it is that data capture form. Describe. Do you understand what describe is?
Yeah, well, this would be, this is a decision of the time. Because this is one who follows the law. Is there a point of question?
Yeah, just you understand. If you don't find that, you understand what describe is.
Yeah, I know.
Yes, you know. Okay. So you agree that it is this data capture form that will load all the information regarding the population. That is provided from the law. It is this data form that is used to populate.
I mean, if that's what the law says.
That is what I was saying. So, have you seen any data capture form so far?
Well, I interrupt with one.
Will be the same one at page 148 of Mr. Jeremy, the Chamber of David. Yes, one page. This one. So, this is the one.
Yes.
Do you know where that's got from?
From the government.
From the government. Are you familiar with the registration of persons now?
I know all this.
No, during your preparation for this case, or when did you see this? And presenting.
Well, no, yeah, I mean, I've interacted with the form.
Did you try to interrogate how it's going? Whether in law or in situation?
Yeah, I mean,
You know how it's going to go.
well, I would assume that there was an attempt at least at a possible and with some basis of law.
Okay. After paragraph 39 of your affidavit, paragraph 39 of your affidavit, you actually specifically mention the existence of a data capture form. 39. We say that the type of personal information protected in the state national master register is expressly stipulated in the digital capture form.
That would be
Now, based on that data capture form, just scan through it very fast and initially identify the government state. If you kindly confirm that there is no other biometric data that this form seeks.
Well, in this particular case, especially when we're discussing about forms, does it specify whether the form should be physical or digital?
I'll ask you whether the data capture form, the physical data capture form, and the data form, and let us just confirm, just so that you can confirm whether other than that correct. But yes, biometric data. No. And so, I refer to paragraph 4 and 5. Would you agree, therefore, based on paragraphs 24 and 25 of the affidavit, where you say that regarding the paragraph 24, regarding the contents of population registers, I observe that it is possible for individuals to be eligible for providing sufficient personal information. When such personal information is selected and the content of population register states are related to competing interest. These are the states that can interest in getting equally important interest in respecting people's privacy. Now, you have also stated that it is the better decision of the state to determine what the form of a national population is. Based on these statements, we will then be fair to the discretion of the government is what constitutes sufficient information for purposes of
I personally did design it.
Yeah, I'm just asking you because it is your statement and you have not said that that is information you have been given by anyone, it is your own personal.
Yes.
And you have said that it is the unprecedented discretion of the government to handle the form and content of the national register and which is the place. We will then be fair to feel that whatever the government has set out here or has provided here is sufficient.
I would say at the moment of issuing the form, I would say I guess yes.
Would you therefore agree that if we have information from the thing that is addressed,
Not for now.
for now, if it was necessary to conclude this address something,
If they do collect this information and it does give them that certificate that through what they collected here they can get that single source of truth, then I would say that.
and for now, what you have before you, right, contain limited requirements of
For what data? Well, there's fingerprint, there's a photo here as well.
exactly. So for now, this is
based on their
Based on
judgment.
yes, exactly. Yes, based on that. So you would agree with me, in fact, it should be the only logic of this thing, that all these other data points set out here, for now, at this very super, for purposes of the first time. If this data capture comes out,
Not necessarily, because I would be contradicting the deterministic nature of as to where you want to get the system to, so that it gives you good results in terms of uh, in terms of actually identifying the person correct. The main aim here is to have a single source, and it needs to give you correct results. So if this to them is minimum, and it gives them the results that they require, then that's something they can judge with for. But if this does not give them what they require, then one way of making the system more deterministic, as you just mentioned, is to get more data.
so, in other words, you agree that the mere fact that this information, this data points described under section 3 of the amendment are not yet included here does not mean that the government cannot collect this information anytime in the future, whenever.
If it fulfills the purpose of making the system more robust,
They can collect, including
if the law allows.
the law. So you do agree that provided it is in the law, and it doesn't matter that it is in this, it is not in this section, government can still collect this.
How would this be?
Now, looking at that form again, do you agree with me that this form requires that every citizen of the Republic must submit it? Must. Right? We don't know. Please read the footnote, the bottom of that page. What does it say?
My number registration is mandatory as per section 9A of the Registration of Persons Act, Chapter 107. It will enable the government to provide you with services. This form and the registration process is absolutely free of charge.
Are you aware that it is an offense to provide this information? Are you also aware that this, the mandatory nature of this law applies not just to collection, but when it comes to processing of information, that there is basically no provision for use consent for the processing by the administration. You know?
No, I don't.
Do you know whether you have a right to request the government to release all your information from the table and to the proposal? At paragraphs 18, 19, 20, 21, and 24, we have made a case for a centralized system. Clearly, that means is neither centralized nor decentralized. That's one on the, from a very basic terms, to view that whether decentralized or centralized. Either systems that we will select right?
Yeah. Um, the concept of centralized or decentralized really depends on where you're looking at it from, particularly with respect to architecture. Because architectures, now just in the few definitions before I stated that, you're looking at, there's a contextual level, then there's a logical architecture, then there's a physical architecture, then there's an operational architecture. So I think the one thing we really need to understand and appreciate is in such large scale systems, we can't oversimplify some of these concepts. So at an operational level, you can have 5 servers that are processing an identity, and that's decentralized or distributed. But at an operational level, you go to one place. So I think that's one of the things we need to really appreciate.
I really don't have problems with whether it is centralized. My issue is assuming it is centralized. You would agree that it is not entirely safe for people.
Well, the choice of architecture is
They are perfect.
I don't think that it's based on the decision that is based on what
Let us go there something. Do you agree that from the step, if whoever is able to bridge the centers, kind of a matter of fact, access the function,
not necessarily.
yes, right? Independently, whoever can bridge the centralized system can bridge the centralized.
Not necessarily as well.
You just said it's either way. Whether it's centralized or decentralized.
There are technologies that can, in fact, not just logically, but actually, what's the word? They can really keep the systems apart based on, I think architecture is like that. There's a new technology now can keep some of these systems fairly independent to reach cover using cryptography.
Correct. So what we have agreed on is you have not seen this.
But I've recommended whether the client uses it or not. It's not up to you.
So you don't know what system. You cannot tell.
But
in fact, in certain paragraphs, you are application. You agree that you can only make those
okay.
Therefore, would you agree that for the common knowledge, we have to discuss? This is almost impossible to understand what this means without publicly available from the administration of it. I mean, you cannot compare yourself to the layman.
My question as well would be,
Let's
okay, sorry.
Okay. You will agree that estimate it is easier to discern, and of course, from the privilege.
And I think that's why you're relying on us.
Recommending the unified identity and identification system, that you're in a better position. In fact, that is why we have so many yes, in support of it. Yes. So you will agree that not everyone in this country enjoys the same privilege.
I would say yes. You know, I mean, I would also say I don't understand law so entirely.
So you would agree that if you are in the position, what somehow you cannot rule out the possibility that perhaps that at the same time and that you have got perhaps wish the same thing.
Wow.
If you are in their position, it's unreasonable by the privileges level. Some of the concerns you have got, you yourself would have got them if you
well, their concerns are indigent.
finally. You know who developed this. You know who developed yesterday. Social denied the government 14. No. This is part of 105, 25. Then there's 6 on the freedom of paragraph 25 and 26. Is it fair to say that the system was developed by several aspects? In fact, you are important to say that this system is a product of non-call.
Yeah, I mean, well, to the extent that I also give advice to contribute. Whereas to the procurement process to the company.
No. I'm talking about the creation of the software, the writing of the code.
Okay.
And in fact, look at the 105 of that document. The 105. What's that? It is a letter from the office of which we have to resolve this application. Right? It is written to who's the first person to the rescue.
Dr. Engineer Project.
So, in short, what I'm trying to say is that NIIMs was developed with the input of various government ministries, departments, and including the Ministry of Interior.
I think
That's a good practice.
because it actually takes into account the context within which that system is to be used, and that's where you should always.
And therefore, if I come to that, do you also know who the administration is?
Well, I've been informed that it's the engineer Project.
Who is in command?
Is the principal secretary of the Interior.
marked just for the avoidance of doubt. Section 9 of the space of section 3. What does it say?
The principals of jury shall be responsible for the administration, coordination, and management.
So you understand that the Ministry of Interior was involved in the creation of the ministry. You also understand that now in law, the Ministry of Interior is the administrator of it. Correct? In your opinion, based on industry best practices, if you agree that it would be necessary for purposes of transparency and accountability, ensure that it means performs the purposes and objectives to which it and it does so in a transparent manner. That an independent authority be created to provide oversight over the ministry, the administration.
We're delving into the question of the operation of companies.
I'm just asking for your opinion.
Well, what I would say is,
Do you think it is best that is it advisable that for someone who created the system and is now an administrator, and bearing in mind the kind of information we have agreed, they have collected, and the susceptibility to that information used, you agree that it would be advisable this administrator to check by some independent.
this human have to be done.
But do you think it's a good practice? You assume it happens in one, so in estimation, it's good practice. And so, in conclusion, we can say essentially that if today the data that was provided, have you registered for me? You don't mind register. If today the personal information that you have provided was to be used for an authorized purpose, it was to be processed by an authorized purpose, it was to be shared with a foreign state or a commercial entity. If you have, you know, especially because of whether NIIMs have the capability to notify you. Yeah. If you know whether NIIMs have the capability of notifying you of unlawful use of the personal person.
I currently, based on architecture and like plans, some of those things, I wouldn't know like that. But I would say probably just from our previous conversation, common practice for systems not work. So there's a way in which that
and you know, when you go to logs, you're delving into very complicated here. Bring yourself down to the layman. So what would the layman, how would the layman know if the information that has been provided to the government has been used in that law? Is there, are you aware of any capability? In fact, if you are advised, would you know whether the full capability provided was not the order of the data for an authorized?
in as much as that use is for the execution of capital business
That is lawful.
and business and
That is lawful.
no, if if, for instance, they access the database to find out what the number of population registers. They want to find out how many people are in a given place for purposes of giving out food or giving out fertilizer or something.
Yes,
So
that's legitimate.
they would have access to your data.
Oh, correct.
Would that be something that I think they need to notify you about? So it's really a balanced question.
Now, this is a question. Let me know because
Yes.
if today you are thinking about unless you understand what it is to do, you must have and that information is given to a third party to determine your institute, your lineage, your criminal predisposition, and everything else that you don't want to know about yourself. Would you want to be notified of that?
I guess I would.
Do you know whether means are currently authorized as capabilities to inform you of that information, whether the administrator voluntarily informs you or not? Do you think it's a good thing that you know of an authorized use of your personal information?
Well, if you see in this particular case, you have to ask yourself why then?
No. I'm assuming worst case scenario. I'm assuming
if
you're
it's-
dealing with all the wrong reasons.
If it's unauthorized,
Yes.
if it is actually unauthorized,
And you think names of the or let me put it this way. Do you
is
think
there
the
technology
administrator
that
of the system, who of course has the control of the who will process it, you think if he voluntarily gives my information without my authority to Mr. X, you think you come and report to me that I have given information to Mr. X knowing very well that you've done an unlawful act? You think what are the chances that you will come and respond?
well, not entirely at that point, but from a technical perspective, if it's something to
Let's
do
go
with
back
service,
to
there are logs to actually show.
let's leave no to people. Yeah, but she's what the probabilities that we have to inform you. But what are the chances? What are the chances that at least they have to come and protect you that have used unlawful use to what are the chances? I mean, just logically. How many people go to police stations to confess that they have to be told?
Well, you see, in that respect as well, you see, if you're assuming if access to the system is authorized, then that's fine. Now we're speaking about authorized access, which is basically a hack, right?
I'm sure I've made my points.
And if it's unauthorized access and it's a hack, the system doesn't necessarily know it's being hacked. You find out that the hack has happened by looking at the log.
Yeah, we're not about hacking. We're talking about
Unauthorized.
in fact, we're talking about intentional sharing of personal information. Remember, by the way, we're running out of time. Go and take care of what's that? Yeah. In this law, I can specifically show you that the administrator of it has very wide-ranging power to use that information and sharing with any person as he thinks fit. So, he voluntarily decides to give up your personal information. You have not consented to that processing. Right. What are the chances that you come and inform me that you have done?
This is a question for the sake of this. The witness is being asked to speculate and to get into the mind of the administrator as to what he would do or not. It's not really going to do that. It's about
No, I think what I'm trying to do is to make a logical example of a scenario. That's a perfectly a legitimate question, because it is a scenario that is like, it is not impossible. It is not impossible, given the provisions of the administrator or given the provisions of this, it is not impossible that the administrator of NIIMs can in fact give out that information to that without the consent of the owner. So what I'm trying to get the witness to, he can actually refuse to attend because they are not. But I'm just and I'm trying to do this because of the expertise. In his opinion, what are the chances that an administrator in the position of clear, yes, after giving out that information, will come and inform it without independent checks and control? But those are the concerns of this position.
There's not speculation and reading of minds. And those arguments that she wants to address upcoming examination, not as the witness is breaking the court, the administrator might do or not.
My ladies, I will drop that question. I have made my point. Mr. Again was protected to that question. And thank you very much for the time.
Thank you for contributing.
Thank you, my ladies. Thank you for the time. I have no further questions.
Okay, I was being reminded by my blog that it was past 1. It's actually now 1:30. Dr. Nyambi, how long will you take to the exam? Under 1 hour. So are we talking about 30 minutes?
About an hour plus minus. We will need but I'm conscious of the fact that I need to be sure.
Yes.
Yeah.
So you want to do it now, or you want to?
I did speaking for myself and then the day there are something that should ask my God. To take a short break, half an hour, then we'll be back. So we didn't do that.
Okay. So we'll adjourn until 10:30. So Dr. Owenga will come back at 2:30 for the examination. It will be easy for you this time. I will adjourn then until 2:30.